I'm sorry for the late start, but I'd like to welcome you all to the Patent Trolls and Patent Reform Conference, co-sponsored by Samsung and Stanford Law School. I'm really excited to have such a great group of people here today and tomorrow for discussions. But right now, it's my pleasure to introduce Colleen Chien, who is currently on leave from Santa Clara Law School, where she's a professor. And she's currently at the White House Office of Science and Technology Policy, where she is the senior advisor for intellectual property to the chief technology officer, Todd Park. Her portfolio there includes domestic and international IP issues, both of which she's an expert on, and also innovation and open government, in addition to innovation in education. So we're very happy to have her back in her old stomping grounds today, and I'd like you to help me welcome Colleen Chien.
Thank you, Sarah, for that introduction, and thanks, Mark, in absentia, for having me here at the conference. I have to thank at least two other people, the creator of NyQuil and the creator of Puffs Plus Lotion, for making it possible for me to be here today. I have a bad cold, so I apologize. I was able to escape the polar vortex snow day earlier this week in DC, but I do have a bit of a cold. So I am grateful to be here today among so many of my former patent colleagues. The technical term we use in DC is geeks. And I'm privileged then to be appearing as a different kind of geek today, a tech policy geek, and more specifically, senior advisor to White House CTO Todd Park. And today I think there are many other geeks among us, law professor geeks, law firm geeks, university geeks, startup and company geeks, and inventor geeks. And I know some of you wear many of these hats at once. But regardless of what kind of geek you are, today's conference topic is one that I think the administration and folks in this room care deeply about, which is ensuring that innovators have the freedom to innovate and can stay focused on innovation and not litigation. But how I want to start today, then, is talking about how very extraordinary, but by other measures not unprecedented, this president's record has been on patents. Extraordinary, but not unprecedented with respect to patents. Because regardless of where you sit in the patent ecosystem, I don't think that anybody can argue that this president's leadership has been quite special. This president is special because after beginning his first term with a message that innovators would be empowered to innovate, he and his staff immediately got to work to make that message a reality. And when Congress sent the Leahy-Smith America Invents Act to his desk in 2011, the president signed into law a once-in-a-generation series of reforms to modernize and update our patent laws. The America Invents Act gave the PTO, the USPTO, tools to realize significant reductions in the backlog of patent applications, shorten the wait time for patent applicants through Track 1, and create cheaper and faster alternatives to district court litigation, which I know a number of you have taken advantage of. The USPTO's successful implementation of the America Invents Act, no small feat indeed, is due to good management, and we know that things are only going to get better under the PTO's new leadership, including Deputy Director Michelle Lee, who came to that position after being born, raised, and building her career right here in Silicon Valley. But this president was also, and this administration, have also been special because as monumental an achievement as the America Invents Act was, it was just a start. Innovation moves quickly, and nowhere does it move faster than in places like here, Stanford, where cutting-edge advances are literally taking place as we speak, and in Silicon Valley, where companies are being born every day. And so the administration has continued to take steps to ensure that our intellectual property laws keep up. On February 14th of last year, in a Google Hangout, the president personally drew attention to what many in the community had been saying and feeling for years, that there was a problem of abusive patent lawsuits, and that it was real. And in that hangout, he said that the AIA went about halfway of where we need to go and vowed to get folks together to try to build consensus towards some smarter patent laws. This call challenged the USPTO, my office, the White House Office of Science, Technology, Policy, the National Economic Council, and others in the administration to come up with a set of concrete ways to curb the distractions and real costs, which can be especially debilitating for small companies and young companies associated with abusive patent assertions. All the while preserving the important incentives that our patent system, the system has been the bedrock of our innovation system for centuries. Most probably do not realize that the PTO will turn 225 this year. Preserving these incentives for innovators to create their works and disseminate them widely. Between then and now, the administration has met with hundreds of stakeholders, some of which are in this room, from across the innovation ecosystem to try to effect continual improvement to the patent system. This led to the release of a paper on June 4th of last year and the announcement of a series of administrative actions, including 7 legislative priorities and 5 executive actions. Many of these touch upon themes that you'll be exploring today in the panels: functional claiming, remedies at the ITC, and the impact of customer suits. But broadly speaking, they focused on the ways in which we, as a society, can try to deal with a discrete set of behaviors that are frankly giving our patent system a bad name. For example, hiding behind shell companies, suing end users, stretching patent terms beyond their meaning, and at root, using a business model that is more about the cost of defense than about the merits of the case. The motivator of this effort was to improve incentives for innovation in the high-tech sector and others, a key driver of economic growth and good-paying American jobs. That's reflected in the membership of the White House task force that worked on these initiatives as well. It was a joint effort not only of the Office of Science and Technology Policy, but also the President's Council of Economic Advisors, the National Economic Council, and the U.S. Trade Representative. We're talking about innovation not only for innovation's sake, but innovation that grows the economy and spurs more growth. Following this announcement, in December of last year, the House of Representatives passed the Innovation Act. It did so 325 to 91 by a large bipartisan margin. No small feat, indeed, in Washington, D.C. today. The House delivered a strong start incorporating many of the administration's legislative priorities. And so, in the State of the Union this year, the President called on Congress to finish the job. Only the second time ever that patents or intellectual property have ever reached the rarefied policy landscape of the State of the Union speech. Now, coming together to finish the job hasn't been the default around Washington these days, but we have every reason to believe that this issue is going to be different and continue to build bridges and alliances across the aisle. There just aren't that many issues in the economy that garner such broad bipartisan support. But our innovation system is diverse, and striking the right balance is difficult. As today's program, featuring the Honorable Judge Dyke, and with a focus on pending legislation, clearly indicates, our executive actions take place within a larger context that includes the other branches of government and civil society. But we applaud the recognition around the table that this is an issue that we can and must take smart action on. My colleagues are also focused on other smart patent policies, the Lab to Market initiative, for example, which is looking closely at taxpayer-funded patent and other IP assets. We're actually going to host our first ever Maker Faire event later this year, welcoming some of the youngest and brightest new innovators. So by many measures, I think the argument is well stated that we've got an administration that has a pretty extraordinary record when it comes to patents. But these acts are not the first time an administration has realized the importance of a strong and effective patent system. Because President Obama and our administration have not been the first to engage on patents. And in fact, when we go back in history, the parallels are sometimes striking. President Kennedy, for example, also thought about the impacts of patent law on consumers. Like this president, he advocated for patent transparency. In his case, the publication of all patent settlements. We in the administration have called for legislation requiring recordation of patent ownership and have taken administrative actions also to make this happen at the Patent and Trademark Office. President Kennedy's administration called for legislation requiring publication of the terms of certain types of settlement agreements. Going back earlier, President Lyndon B. Johnson also made patent policy a priority. He ordered a presidential commission to study and recommend improvements. You've heard about this White House's executive actions on patent reform, and I'll tell you more about them soon. But back on April 8, 1965, the Johnson administration also issued Executive Order 11215, establishing the President's Commission on the Patent System. On January 10, 1947, President Harry Truman discussed how the, quote, Patent Office urgently needs increases in personnel to cope with the growing backlog of patent applications. President Teddy Roosevelt, worried about how large corporations might be misusing the patent laws to hurt little guys. And in 1816, President James Madison recommended, quote, guards provided against fraudulent extraction of fees by persons possessed of patents. So you can hear and see that the issues of today have been the issues of the day for many presidential administrations, both Republican and Democrat, and how the administration that I am proud to be a part of is indeed extraordinary when it comes to patents, but also very much grounded in the best presidential tradition. So speaking of executive action then, when the president made his historic mention of patents in the State of the Union address earlier this year, he also talked about how 2014 would be a year of action. And so I'd like to spend a few minutes now talking about what the administration has done, what it's planning to do, and how you can be engaged in helping to strengthen and improve our patent system. Now, last summer, the administration announced 5 patent executive actions, and last month we announced 3 more. And I'm going to talk about them and how, again, the talent in this room can brought to bear on some of these efforts, and indeed much of it has already done so. Our first executive action was about attributable ownership, and it aimed to bring greater transparency to patent ownership information to the public. The PTO has began a rulemaking process, which is now underway. Now, of course, there's also things happening in Congress, and we're pleased to see that transparency has been elevated to something that the legislature is now actively considering. Under the PTO's new proposed rule, which reflects significant public input, the USPTO would collect patent information for a patent or application and make that information available to all on our website. The result would be increased transparency aimed at enhancing competition. It would be easier to know what others are holding, facilitating technology transfers, helping to ensure the highest quality patents, and leveling the playing field for innovators. Now, one aspect of these proposals which I'd like to draw your attention to hasn't received as much attention, and it pertains to the reporting of licensing information. The question is whether the USPTO should enable patent applicants and owners to voluntarily report licensing offers and related information to the office. Such information can include willingness to license, as well as licensing contacts, licensing offer terms, or commitments to license the patent, for example, on royalty-free or reasonable and non-discriminatory terms. The government has one of its greatest assets is its brand, and also its ability to be a touch point for many that are in the ecosystem. If the PTO could collect this information about licensing information, it would then make it accessible in an online format and federate the different silos of information that are out there. The listing of information would be completely voluntary, but it could reduce the information search costs associated with finding technology and transferring it through a license. And we aren't the first ones to think of this. In fact, the PTO already enables some version of this option and publishes the information in its Gazette. And the WIPO is conducting a pilot program that enables licensing information to be provided by PCT applicants, and has also launched the GREEN database to enable this type of information to be found internationally. Because as we all know, the licensing marketplace is growing and contains untapped potential. Look at examples like the Association of University Technology Managers, or AUTM, which maintains a global technology portal where you can find different university technologies to license, or the Federal Labs Consortium, which offers licensing information about federal assets which are available for commercialization. Now, the administration is looking at not only IP assets, but also equipment assets and others that taxpayers have put their money into, We want to make sure that these are delivering value to the public and are technologies that are getting out there. And so these initiatives are of interest for various reasons. Because we know that the patent system, through voluntary licensing, enables today's university labs breakthroughs to become the basis of tomorrow's startups. And we want to do all we can to facilitate these transactions and new businesses. The USPTO is collecting input from the public on this rule and hosting an event in San Francisco at Hastings School of Law on March 26th. I encourage you to get in touch if you'd like to participate. Written submissions are also due until April, or are being accepted until April 24th. Another area that we focused on last year with respect to executive actions was on increasing claim clarity. We recognize that a patent with clearly defined boundaries provides notice to the public to help it avoid infringement and costly and needless litigation down the road. So this executive action around tightening functional claiming called for new and targeted training for patent examiners to scrutinize certain types of claims that may be overly broad and to increase patent clarity in general. Now, since this executive action was announced, the USPTO has implemented a multi-phase training program for all examiners to take more note of functional claims and to examine them. This new training improves patent clarity. The PTO has also been engaged with numerous public engagements to share ideas, feedback, and experiences, and they continue to accept that input. Now, this is an ongoing training, and I encourage you to engage with the PTO and us as we try to work together to improve the clarity of patents. Our third executive action from last year was focused on empowering downstream users. And this action called for new education and outreach to assist those receiving a patent infringement letter. I hope many of you who are practitioners have looked at the website. If you haven't yet, I encourage you to go online and do so. It's at uspto.gov/patent litigation. And the toolkit was really created with the goal of helping level the playing field for smaller Main Street retailers and consumers, those who are not steeped in patent law or who cannot afford teams of attorneys. If you get a letter, you can use the tools linked to on the site to find out information about whether the patent has been asserted, who owns it, and other details about the person who might be behind the assertion. We know of no other online resource where a recipient of a patent infringement letter can go to get as much information as available in this toolkit. I encourage you to check it out and use it especially when you're counseling your smaller clients. And importantly, there is also a two-way communication stream so that the public can assist us in identifying additional, and we hope even better, resources for all to use. Finally, the fourth executive action from last year with respect to the Patent Office called for an expansion of the PTO's already extensive public outreach efforts, as well as more empirical research. And that will be a topic that's obviously of importance to the folks in this room. I've already mentioned some of the outreach, which we've ramped up from an already high level. As for empirical research, the PTO has expanded its Thomas Alva Edison Visiting Scholars Program and has already recruited 3 distinguished names that will be familiar to many in this room: Joshua Sarnoff of DePaul University, Jonas Anderson of American University, and Elizabeth Bailey of UC Berkeley, who will research key issues related to patent litigation. By engaging legal and economic scholars with agency experts, we anticipate a wealth of new data and research. Now, building upon the progress made by the American Invents Act and the first executive actions I've just outlined, in February, we also committing to doing more still. That month, we announced 3 new executive actions to further level the playing field for innovators and ensure the best quality patents. Through them, we're leveraging crowdsourcing, the same enthusiasm that brought you here today very early, multiplied by thousands of innovators across the country. We hope to get more information into the system when examiners are considering patent claims. Likewise, we're asking companies to join us in delivering training on the state-of-the-art across technical fields to ensure that government keeps up with industry. And we're going to provide better resources for independent innovators who want to get a patent but don't have the resources. All of these will make the program better, stronger, and more accessible. So let me elaborate briefly, because we're excited about these new initiatives. First, crowdsourcing prior art. As we all know, to ensure that U.S. patents are of the highest quality, our patent examiners must be skilled in understanding the technology to which the invention pertains. But innovation moves quickly, and important advances may not be documented in patents, but rather in corporate records, in the marketplace, or any number of other non-patent silos. The USPTO is committed to making it easier for the public to provide relevant prior art in patent applications, including by refining the third-party submission program, but also exploring other ways for the public to submit prior art to the USPTO, and to also updating its guidance and training to examiners to more effectively use crowdsourced prior art. Through roundtable discussions and other interactions with stakeholders, we'll gather insights as to how the USPTO can better leverage crowdsourcing techniques to increase our examiners' access to prior art. Many companies and associations have already stepped up to partner with the USPTO to ensure it has access to the best prior art. But another big problem is how to find, among a sea of documents, the most relevant ones, especially in areas where terms are non-standardized. We will select a Presidential Innovation Fellow to help with these efforts, or PIF, as some of you might have seen mentioned in yesterday's Patently O article. And we're excited about this, and we're hoping for your help as well. This Presidential Innovation Fellows Program pairs top innovators from the civil sector with top innovators in the government to collaborate in focused 6 to 13 months tours of duty. It's been responsible for some extraordinary accomplishments in its first 2 rounds of its existence across the government. The USPTO will have its first PIF to help increase the volume and relevance of information provided to the agency by identifying and piloting effective approaches to tap into the relevant innovation communities. Applications will be accepted through April 7th, and encourage interested members of the public to apply. We could really use your help in getting the word out and helping us try to crack the patent quality nut and bring top innovation talent to these challenges to ensure that U.S. patents are of the highest quality. There's also going to be a roundtable on April 10th on crowdsourcing, and I encourage you to participate in that as well. Related to this executive action, we're also engaging in making sure that the PTO can expand its existing program and make sure that there is robust technical training and expertise so that experts in industry and academia can provide relevant technical training and experience to patent examiners. Now, the USPTO has long recognized the importance of ensuring that patent examiners be fully versed in the very latest advances in their technological fields in which they practice examination. And they've long had strong partnerships with industry, for example, with the biotechnology community. A full understanding of the latest in technologies ensures robust prior art examination and application of the knowledge of people in the field to the actual application process, which is supposed to reflect the insights of a FOSITA. So the USPTO will do this by expanding its existing patent or examiner technical training program and trying to bring more technical training and experience to patent examiners. This program enables experts in industry and academia to do in-person and virtual training with examiners, and with the assistance of the new Presidential Innovation Fellow, we are aiming to ensure more regular and impactful training across all technological disciplines. We also plan to make use of our satellite offices to better connect with innovators in these communities located in every time zone in the continental United States. Increased technical examiner training will result in a stronger examination process, which will increase the quality of patents. Finally, our third executive action is aimed at connecting under-resourced independent inventors, entrepreneurs, and small businesses to the power of the U.S. patent system. And we call this our pro bono support executive action. As many of us know, due to the complexity of intellectual property rights, under-resourced independent inventors, startups, and small businesses often struggle with navigating and filing their patent applications. Assistance from the USPTO or from a patent agent can be a critical resource in preparing the necessary documents to help ensure that a quality patent that protects the invention is issued as expeditiously as possible. By minimizing this often costly obstacle for those looking to take their ideas from the garage to the marketplace, inventors and entrepreneurs will be better suited to protect their inventions in a global economy. The USPTO plans to provide dedicated resources to those who lack legal representation by working with our partners through a newly appointed full-time pro bono coordinator to expand the existing pro bono program established under the America Invents Act to all 50 states. And I think this executive action, as do the other two, create a kind of dual public-private support structure that will help, again, to level the playing field for individual inventors and small businesses, ensure patent quality, and make sure that the U.S. can continue to issue high-quality patents. Let me just wrap up then by saying that what's happening in this room and on this campus and in this community is of deep interest and engagement for the administration. With your help, we can all work together to ensure a level playing field, the best quality patents possible, and make sure that innovators can stay focused on what they do best, innovate. Please consider offering, and in many cases considering to offer, your talents, your time, and your platforms to help in the ways that we've talked about, submitting comments to the USPTO, helping us access the best prior art and figure out how to get that in front of the patent examiner, participating in roundtables, and getting out the word with respect to our Presidential Innovation Fellows program. Please also continue to think about and let us know what we can do to continue to improve the patent system. As innovation moves quickly, let's work together to make sure that our intellectual property system stays ahead and continues to lead the world. Thank you very much.